Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. This is Ericka Adler. Welcome to the Health Law Hotspot. Just to introduce myself, I'm Ericka Adler, shareholder at Roetzel and Nancy, and leader of our healthcare practice. And today I have one of my colleagues from the Tax and Estate Planning Department, Nancy Franks-Straus. Thanks for joining us so much today.
Thank you.
We're going to be talking about something we haven't talked about before, which is what should healthcare providers be doing to prepare themselves in terms of estate planning, in terms of potentially one day having a disability. What kind of planning should they have in place? So thanks for joining us, Nancy.
Thank you. Happy to be here.
Why don't we start by you just explaining exactly, what is estate planning? I don't think everybody really knows what falls in that category and what might be something that like a financial planner might do. So why don't you explain a little bit about what we mean by that?
Well, when someone asks me, what I do for a living, when I meet them, I say, well, I'm an estate planner. Then they dig a little deeper and say, well, what exactly does an estate planner do? And my answer is, well, I focus on death and taxes. And I usually get a chuckle on that. But then I explain it really isn't just death and taxes. Estate planning is essentially planning for disability during lifetime and for death. So it's, taxes can be a very, very minor part of estate planning, but the disability planning, making sure that you have someone that you trust who can make decisions for you if you can't, making sure that you financially provided for your loved ones, the people you care about in the event of disability. Very, very important. And disability covers, you're looking for someone to make financial decisions as well as healthcare decisions. So those are, the things that we keep in mind for disability planning. For death planning, again, we're looking at making sure that there's adequate provision for loved ones financially, but in addition, making sure that you have documents in place that state who you want to get your stuff, when you want them to get it, and who you trust enough to manage it during, after your death. And then finally, if you have minor children, you name a guardian. Someone you'd like to take care of your child if you and the child's other parent were no longer living. So that kind of in a crux is estate planning. There's more sophisticated aspects of that.
Sure.
That asset protection planning, especially for physicians, some other and tax strategies. But I think that might be the subject of, our next podcast.
Yeah, for sure. So when people think of estate planning, sometimes they are thinking, I don't really have any money. I only have debt. And I hear this a lot, especially from young physicians. Is estate planning something you only need to do if you actually have money in the bank?
That's a really good question. And, my response is if only people with money in the bank could become disabled or would die, then definitely no one else would need to worry about estate planning, but it's a little more even-handed than that. And, the likelihood of any of us dying is 100%. The likelihood of disability is actually pretty high. Not for younger people, but once someone turns 55, statistics show that they are 5 times more likely to become disabled than to die. So that's kind of a sobering statistic.
Right. So for young providers out there, this is just as important as older ones. And obviously people feel like if they don't have a family yet or they don't have children, they don't need to worry about it, but you still need someone to make decisions for you and to plan ahead. So it is worth it. And a lot of them sometimes are very afraid by how much things cost, right?
Right.
But I think,
Right.
Obviously more simple plans are less expensive than very sophisticated, complicated ones like anything else. So that shouldn't really be a deterrent to talking to someone to get this done.
And Absolutely. I mean, my thought is that, I'm sure by the end of today, everyone watching this will say, gosh, I need to do an estate plan or update my estate plan or recheck
Right.
it. But, and for that, I'd say, talk to friends who have done it, talk to financial advisor. If you have a financial advisor they've definitely worked with, or an estate planning attorney. Accountants are a good source of getting a feel of who, they probably know several attorneys, and attorneys run the gamut from, relatively low cost, flat fee to
Right.
super sophisticated. So,
Yeah, no, absolutely. And I think though, the number one thing I hear is like, either I don't have the money to do it or I don't have anything worth owning. But this is really more than that. Let's talk about disability in a little bit more detail first, and then we'll come back to, more traditional estate planning. So many physicians that I talk with assume that, whatever they have through their work or their fellowship or training program, oh, I have a disability policy, I'm going to be covered. Okay. And I think you and I agree that often, depending on how much the doctor is starting to make, or they haven't looked at it in a while, it may not actually match kind of what their compensation might be. And that's something I like to warn doctors about as well. But I have seen some very tragic circumstances, and I work, with doctors where a doctor has become ill, can't work anymore, fallen and hit their head, and is not quite able to do the job, and they get let go. And there's a little bit of, there's different pieces of the disability. One is when you get terminated from your job and how soon that can happen. The second is how long will compensation continue until you get terminated, right? And that's something you have to look at your employment contract for. The third is, when does the disability policy kick in, right?
Right.
And so those are the kind of things that I think about as a contract person. But literally, my job kind of ends there. Whether somebody has enough disability, whether they should have had multiple insurance policies, et cetera, is something that I try and direct my clients to get advice on. I think some of that might come more from the financial planner aspect of it. Where do you see your involvement in the disabled provider situation? So where does your role come in there?
Our role comes in, one, if we're working with someone, to recommend that they do talk to a financial advisor, or possibly, we do work with some really phenomenal insurance people. But insurance, often the term will make people shudder, but just, to do a check on the financial end, that isn't so much my end. I'm looking at, let's get a person covered so that in the event they really are incapacitated, they can't give what I say prompt and intelligent consideration to either medical decisions or financial decisions. I want to get documents in order that will name people that they trust to make decisions for them if they can't.
And some of those might be whether they really can work or not anymore, right?
Well, they certainly, if someone were impaired, let's say, then, the person representing them would be the one that would, be able to hire the lawyer to enter into negotiations as far as coverage or any other legal aspects. So, when I say financial matters, the property power of attorney is the document in Illinois that covers, financial matters, non-healthcare, but it runs a gamut of, not just bank accounts and investment accounts and retirement accounts, but negotiating contracts and filing tax returns, and, making other decisions. Do we need to sell, the residence? So someone acting under this document has a lot of leeway, a lot of authority. So to me, it's critical that there's upfront planning to name someone that is really trusted. We've seen some horror stories where people are named and they're not really trustworthy.
Right. And sometimes it could be just a temporary situation. I recently had a physician with a brain tumor, and he did recover, but it took quite a long time. And I know he spoke to us right before he knew was having surgery, etc. So we could make sure that the estate planning was in place, and he did temporarily require that assistance, but eventually was fine. So that's an example of, it's not like the end of life type of disability always.
Right,
Sometimes an
right.
interim type disability, correct?
Correct. Right. That's and exactly for financial, someone that it's the agent would represent the physician only during disability. And same with, the healthcare decisions. It doesn't go on forever if the incapacity terminates. So once
Right.
someone gets, retains their abilities, then there's no need, then he or she can make their own decisions.
So what happens if you don't have one in place and you become disabled?
Well, the general rule, especially for some more involved decisions, with financial matters, there's no choice but to go to court for a guardianship, also known sometimes as a conservatorship, which is it's a court proceeding. The financial aspects of the physician become public record because an inventory needs to be filed showing all the assets and liabilities and income. And it's also the disability, the detailed doctor records of why this person is incapacitated need to be filed. And then eventually someone is appointed as a guardian. I shouldn't say eventually, but it's a process. And then someone is appointed as guardian
Right.
who has
Right.
the legal authority then to act on behalf of the incapacitated physician. The thing being
Right.
that the whole purpose of the property power of attorney is to avoid the expense and publicity, public nature, and expense, of the guardianship. And I will just say, if a disability goes on for lifetime, so does the guardianship, and there needs to be annual accountings of, again, income and expense, and the guardian needs to ask permission to do certain things. So it's really in many circumstances, something that all of us would like to avoid.
Right. Yeah, no, I totally agree. Now, there's a tad off topic, but a lot of my doctors who are like maybe my age that I work with, we have children now that are in college.
Mhm.
And something that a lot of us have talked about recently is whether we should be having our 18-year-old children sign something before they go away. And I'm only bringing this up because we assume that it's going to be somebody having an issue as they get older. But, if your child is injured and in an accident, especially in another state, and they don't have those documents, they fall under these very same rules, correct?
Absolutely. And excuse me, it's funny that you say that because every year I give a presentation to high school seniors and their parents about the importance of having the healthcare power of attorney and the property power of attorney. Because in Illinois, when a child turns 18, they are an adult. And all of their medical information, any medical decision making becomes theirs. That the parent is no longer really even, shouldn't be given any of that private medical information without authorization, even if they're paying, health insurance premiums, all costs associated with care. And you're absolutely right. It's something that, as a matter of course, any child who attains age 18, especially if they go to college, should have
Right.
those powers of attorney.
And it's funny because a lot of doctors I work with deal with them when people come into their offices with the power of attorney, for the patient, but very rarely are thinking about it for their own family.
I would say most people don't. I would say many lawyers don't.
Yes,
it's just,
right.
well, you even estate planning lawyers, you just don't think about it.
Right. All right, so let's talk a little bit about death then, unfortunately, and how estate planning is needed for, planning for that eventuality. When do you need to do this? What are some of the things that you should be thinking about when you do start thinking about, your eventual demise?
Well, it's, I think many of us, kind of starting out in life, think that estate planning is only, again, it's only for the wealthy, only for people with, a whole lot of money in the bank. And, from my perspective in planning for death, I think it makes sense, it makes sense when someone starts, accumulating some assets. And with that said, I'll say, I think it makes sense to have it regardless, because it makes sense to have the powers of attorney no matter, how rich or poor someone is, whether they're starting out or they've been working for a number of years and are quite comfortable. But along with the powers of attorney, just get a simple will put together that, goes through, in the event of my death, I want so-and-so to handle things. And I leave whatever I may have, even if I have nothing, to these people. And the reason I say that is, one of the things that we see with physicians starting out is pretty significant student debt, student loans. And just to be able to have appointed someone who can step in and start dealing with those student loans, working to get them forgiven, is important. So I recommend that even without assets, but certainly as there's assets in the bank, maybe looking at buying a condo or a residence. At that point, I think it's quite important to have a will that says, in the event of my death, I want these people to get, my assets.
So how often should you be updating it or changing it? Like annually, should you review it? What's
my rule of thumb is whenever there's, kind of a major life event. And with that, it would be, major life event of I'm starting out and I have money now, I'm buying a condominium. Gosh, I'm looking at getting married because there will be implications with that. We just had children. Well, the importance of appointing a guardian, any documents that were done prior to having children need to be revisited so that a guardian can be added. Gosh, my marriage isn't working out so well. I'm thinking of filing for divorce, or I've filed for divorce. That's a critical time, an absolutely critical time to revisit. I'd say to revisit documents, or if you don't have any documents, then that would be a really important time to put together some estate planning documents. After a divorce is final, another time to look at things. And then, in the event a family member becomes incapacitated, or anyone that has been named to make decisions, under the powers of attorney for disability or the will, I spoke to somebody last week, and under the will that this person had left, they'd named 3 executors. Well, one lived overseas and couldn't serve. Another one had dementia and couldn't serve, and the other one had died. So we had nobody left that could handle it. So, and then of course, if there's a death in the family, that I won't say revisit it then, but that often will make people say, gosh, this has been a mess, and maybe I'd better look and make sure I've got everything in order.
So what happens if you die and your family can't find your will, or you didn't have one? What happens next?
Well, if you reside in Illinois, the state of Illinois will write a will for you. It's right in the probate code, and Illinois sets out very, clearly, if you die unmarried, then this happens. If you died married with no kids, this happens. If you die married with kids, this happens. So they go through exactly who will get your stuff. The statute also will say they have a priority on who can serve as executor under the will, who can manage things. And then if there needs to be a guardian appointed, that's where we can get in a little bit of tug of war that I've seen between each parent's side of the family may want to serve as guardian. And if there hasn't been a choice made, in a will, that can lead to a little bit of friction. So anyway, the statute and the courts, the judge will decide.
Right.
Ultimately.
Are most states similar to Illinois? Like they have similar provisions?
I believe so.
And so
and
you
the
need
reason-
really, and estate planning is one of those types of law where you really need to talk to somebody in the state where you are. So
yes,
yeah,
and that's why my
very,
answer.
right,
Sorry.
general principles here,
Yeah.
but you really need to talk to somebody
Right.
local. So,
Right.
so I'm guessing then that the law takes into account, kind of what was going on, what assets you had before you got married, if you died while you were married, how old your children are, etc. Like, for example, if you have a will and your 3 children, let's say, were minors when you wrote it, and now 2 are not minors and 1 is, you might want to go in and say, you know what, the children that aren't minors anymore can be the guardian for the one who is a minor or something like that, right?
Exactly. And the other thing I might add is, relationships change over time. So if a will was written 15 years ago and someone appointed Joe, we want Joe to serve as guardian, but now they're on the outs with Joe, or Joe isn't going to be the perfect role model to serve as guardian, then we should look at replacing Joe with somebody who's more appropriate.
Right. That totally makes sense. So do you really, there's so much stuff available online now. And I know a lot of people just go online and like download a power of attorney or download a will. Can this work? I mean, the companies selling this are kind of selling it as though we have everything you need right here. Is that the case? What kind of mistakes do you end up seeing when people do that? Or, what else do people need to know about that?
Well, it's, I can say I'm biased as a lawyer, that I think that lawyers are better suited to drafting estate planning documents than, a capsule online. But I think the thing that really concerns me about the do-it-yourself is, they kind of sell just check out these boxes that apply and we'll spit out a will. And the thing is that it doesn't take into account all the circumstances. It can't ask all the questions. It can't find all the facts.
Right.
That, to me, a good estate planning attorney is good at listening for the silences, of getting all the facts that come out, even those that the client doesn't want to talk about. That's critical to doing the right documents, the right provisions for people. And the do-it-yourself online just simply isn't equipped to provide that. So that's one thing I'd say. The substance of the documents is often not appropriate for someone's situation. But I think the worst examples that we've seen, and the ones that tend to cross our litigator's desk, are documents that weren't signed properly, documents that they're very special provision, they're very special processes for signing a will. And if someone didn't follow that, then their will is invalid. So they wasted the money,
right. And then
doing it.
And then I guess what happens if you can't find it? I mean, there's a lot of estate planning lawyers that are kind of, single practitioners. And, what happens if they pass away, or what happens if they're, I guess, how do you know what happens to your will? Because a lot of times the lawyers will hold on to the original in case,
Right.
But what happens if they're not there, or nobody knows what lawyer was used? I mean, how do do they get registered somewhere, or how does this work?
Well, that's a really good question. And I will say, because, although there is a place to register wills with Illinois, as a general rule, either the client will keep, their original will, and we tell them, it must be in a safe deposit box. It's got to be safe. Let people know where it is. Or we as lawyers will keep the original. And I mean, the problem, we've run into this, a number of times, where we know someone died and we can find copies of the will, but no original. And if the original is missing, it is presumed to have been revoked. So if it, now, with a great deal of work, we often can get, I shouldn't say often, we have been able to and can get a will
Right.
admitted, a copy of a will admitted to probate, but the better idea is to don't go there, because that's no guarantee. It depends on the judge and the circumstances and the family. If there's family agreement that it should be admitted, okay. If the family doesn't agree, then it can be, tens of thousands to hundreds of thousands in litigation.
Wow.
Yeah.
All right. Well, God knows there's like a lot to think about here, right? So what are some of the final thoughts that you have on things people should be thinking about now? I know, I mostly work with healthcare providers, and I'm urging my young docs and even my more senior docs to think about estate planning and think about powers of attorney and preparing for disability. These are things, they're only human, and these things
Right.
affect them. And a lot of times they are, they're too busy, or they're just not thinking about it. Like you said, they don't think they have enough assets, they only have debt, etc. But this is something everyone should be thinking of. And I think you've really helped make that super clear. Are there any final things that we haven't covered that you really want people to think about?
I think, there are a couple of things. One is, what we didn't cover is we've covered, disability and death planning with wills, is beneficiary designations. One thing that everyone can do, and it's not, you don't even need to call your lawyer to do it, is look at your beneficiary designations. So many of our physician clients have, defined benefit plans, 403B, various retirement accounts with significant balances. And, it's critical that the beneficiary designation be revisited, because God forbid it, if it's an ex-spouse, then the ex-spouse is the one that is going to receive that benefit.
Wow.
There's nothing in Illinois law that would,
So the will
prohibit that.
doesn't overcome the designation.
Not for retirement accounts. There are other, for insurance, it can. But beneficiary designations for insurance, annuities, retirement accounts, very important. Look at the primary, you can generally put in a secondary or contingent. Very important to have that done. And then the other thing is just ownership of property. It's not unusual for two siblings to own real estate. Well, how is that titled? What happens when one of those siblings dies? Does winner take all? Does it go to the other? Does it go to, the deceased sibling's family? Maybe it's a spouse no one gets along with. Maybe it's a never-do-well child no one gets along with. So those are things that also play into it. But I'd say, the main thing is procrastination, inertia. I mean, nobody wakes up in the morning and says, I can talk about death and disability today with a lawyer. It's just not, it's not where anyone wants to go. But, I would say that it's the kindest thing you can do for your loved ones, is to put something in place so they don't need to handle the mess later on.
Right, absolutely. And, for physicians in particular, in most states, they are the only ones that can own their ownership as well in their practices. And,
Right.
The way we write our documents, in the event of death, they're immediately terminated, and their stock or units are redeemed back to the company, and the formula is all set out there. But, there are plenty of groups that don't have written documents, or their documents don't say that. And companies, like non-healthcare companies, where suddenly the stock held in a company, the family is trying to step in and not just own the stock, but take over the role and running the company, etc. So definitely also want to look at this from a business perspective.
Absolutely.
What do you own an interest in? What, do you have an operating agreement? Do you have a shareholders agreement? What do they say? Do you want the family to be able to come in? Do they just stand in the feet, the shoes as an owner, or they get to have a say in things, right? Just as you kind of said. So lots of decision making, but this is really just kind of a starting point for people to really think about how they're impacted by disability, death, and those kinds of things. So this is really helpful. Thank you so much for coming and talking with us today. And I just want to let everyone out there know that if anyone has any questions, we didn't go into a lot of depth on things. There's just too much to cover, but Nancy is totally able to answer any questions you may have. And I would not be the right person to direct any of these questions to, other than to make an intro. So if you have any questions, please feel free to reach out to Nancy directly or email one of us and we'll get you to the right person. And thank you so much for joining us today. I think it's been really helpful.
Thank you.
Thanks everyone for joining us at the Health Law Hotspot. We'll see you next time. If you want to catch some of our other podcasts, you can check out ralaw.com. See you next time.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.